(2018-214) State of Arkansas versus Dusty Rhodes. This matter is down on the court's trial schedule for the week of March 25th, with an next appearance scheduled for March 21st. And the reason he's back incarcerated because of an alias warrant that was, I'm gonna look up when it was issued, but anyway, there was an alias warrant. Where do we stand at this time?
Your Honor, I visited Mr. Rhodes this week, and he expressed an interest to go into care center. I don't believe the state is opposed to that if he would go straight from jail to care center, and there is no promises made from the state other than they have no objection to the program. So I would make that motion, Your Honor, that if care center goes down and sees him, I don't believe they have screened him yet, that...
They screened him.
Pardon me?
Do we have a screen?
They screened me yesterday, sir, and they said they were going to send an acceptance letter.
We do have an acceptance on him, Judge.
In our position to state that if the court does not object, we will not contest him going there. The state wants Mr. Rhodes, as Mr. Cooper has already said, to understand this has no impact on the ultimate outcome of this particular case, though, Your Honor.
Okay. Well, the court, and normally in these circumstances, the court's required to essentially approve an OR release of the individual. The court's hesitancy on that is that the defendant is in custody at this time, having been out before, is in custody on an alias warrant when he failed to appear back in November. So that's one problem the court has with that. The secondary problem is that we're 6 weeks out from a trial date, and I don't want the defendant to think that entering Care Ministries is going to excuse him from facing that. I mean, I want to continue the jury trial at this point. I'd rather see a disposition, which could include going to there. But in the circumstances we have today, what the court will approve is because of the alias warrant, the court's going to require him to post a $1,500 cash or professional bond. The bond will be conditioned upon him arranging transportation directly from the jail to Care Center Ministries, and if he leaves Care Center Ministries for any reason, he's to immediately report back to the jail. The bond is only to have him out to Care Center Ministries and no place else. Other standard conditions of a bond will apply as well, but that's the primary condition on the bond, is that bond will be for that purpose only.
Your Honor, I don't know if he heard what the court said about the bond. It was going in and out. Could the court repeat that, please?
All right. Mr. Rhodes, the court's concern, normally I would be hesitant to release you on any basis. I don't have any objection to you being in Care Center Ministries. It's the fact that you had to be arrested on an alias warrant because you didn't show up in court that's causing the court concern. Therefore, the court is imposing for you to go to Care Center Ministries. The condition the court puts on it is that you'll have to post rather than being OR released to go there, the court's going to impose a $1,500 bond. That'll be a cash or professional bond, and it'll be conditioned upon you being at Care Center, getting to and being at Care Center Ministries, and if you leave there for any reason, the court's order is that you have to report back to the jail immediately, and we'll discuss a different bond arrangement if pending trial if you don't stay at Care Center Ministries. That's the order of the court,
Thank you, Your Honor.
all right?
The reappearance date of March 21.
You got a March 21st reappearance date with a trial scheduled during the week of March 25th. You may be excused, sir.
Thank you, Your Honor.
All right. We have 2019-44, State of Arkansas versus Daniel Hodge. This is a first appearance for plea and arraignment, I believe, on charges of commercial burglary and theft of property. The commercial burglary is a Class C felony. The theft of property is a Class A misdemeanor. Court has before it an affidavit for the appointment of the Public Defender's Office. Based on what's shown in the affidavit, the court's approving the defendant for representation. All right, defendant's approved for, court's approved for participation, the court's approving the Public Defender's Office to represent Mr. Hodge. On the charges involved, how is the defendant now plead?
Not guilty, Your Honor.
That plea of not guilty is noted on the record. The court will set this matter down for trial by scheduling order. The case is set for trial during the week of August 19th of 2019, and it'll be set for a reappearance on May 2nd. This is a pretrial on May 2nd of 2019. And the court would advise the defendant that I've appointed the Public Defender's Office to represent you. It's your responsibility, if you were to bond out, to get in touch and stay in touch with your public defender. What that means is if you're released, you should contact the Public Defender's Office and set up an appointment and then keep that appointment. Your next appearance in court will be scheduled on May 2nd. The documents in the file reflect a $5,000 bond has been set in this case. Is that the bond that everybody understands applies to this case?
That's the bond I understand, Your Honor, and we're not asking for any change in that today, Your Honor.
So the bond is a $5,000 cash or professional bond. All right. You may be excused, sir. 2018-270, State of Arkansas versus Michelle Woods. Mr. Cooper, where does this matter stand? It's set for trial during the week of February 25th. Is this on for trial, or
Your Honor,
at this point, where is
what
it?
we have been waiting on was to get the evaluation back. The evaluation,
Okay.
the evaluation is back. We only saw that, Mr. Etheridge and I only saw that yesterday, and it's actually in two
I
different
see.
evaluations, but
I see.
and it's quite lengthy.
Filed in the case file. Let me quickly review that. There was a criminal responsibility also?
Yes, there was, Your Honor.
What I've found so far only makes reference.
It's done in two separate reports, which is a little unusual.
I see. Here's the other one. Well, we need to set this down for a hearing on her capacity at the time of the crime.
Your Honor, I would like a chance to thoroughly review this report. As I said earlier, it's voluminous, and also visit with Ms. Wood about the report. She's been in jail for 7 months. I visited with her on Monday or Tuesday. If we could have her reappear on the 21st, I won't make a motion at this time to continue her trial, but there may be a disposition we can come up with by the 21st.
All right. We'll set it down for hearing on February 21st. That's when Ms. Woods is to reappear, and we'll take up this matter again on that date. All right. Ms. Wood, you may be excused. 2018-252, State of Arkansas versus Kevin Gertz.
Good morning, Your Honor.
Good morning.
Your Honor, I was gonna say real quick, I'm really willing to do anything in order to not spend any more jail time, if that's at all
Your Honor,
possible.
before he says anything more, let's just bring him over when we bring the inmates over.
Okay. All right, that'll be the order of the court. I'll direct that Mr. Gertz will be brought over for the afternoon session of court. All right, you may be excused. 2018-524, State of Arkansas versus Robert Lambert. Apparently on December 20th, he appeared before Judge Putman and was told to reappear on January 17th in front of this court for attorney status and arraignment. On January 17th, he failed to appear in front of, when Judge Laser was substituting for me, and a alias warrant was issued. So it does not appear that he's ever been arraigned. Mr. Lambert, you're in front of the court today for arraignment. Before we go into that, have you made any arrangements to be represented by an attorney?
No.
Well, just so you understand, you have an absolute constitutional right to an attorney. What that means is you have the right to hire the attorney of your choice, and the court doesn't get involved or interfere with that private contract. However, if you cannot afford to hire an attorney, you still have the constitutional right to an attorney, and the way at that point you're entitled, if you can establish you can't afford to hire an attorney, then you have the right to have an appointed counsel. But before you can get appointed counsel, you have to request it. You do that by filling out an application for the public defender's office. Those applications are there at the jail. I believe I explained this to you 2 days ago. So you're going to go for a public defender, then you need to take the action to fill out the application and turn it in, and it'll get to the public defender's office so that we can it can be reviewed, and an appointment of the public defender's office can be reviewed. Do you understand your rights with respect to representation of counsel?
Yes.
All right. Your charges against you are theft of property, a Class C felony, 2 counts, breaking or entering, a Class D felony, 3 counts, criminal mischief, a Class D felony, and then a separate criminal mischief, a Class A misdemeanor. On those charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. What action do you intend to take with regard to acquiring an attorney?
I'm gonna apply for the public defender's office.
Okay. I'm noting down you're applying.
Your Honor, I just made a mistake and mixed up the court date from here with the one in Harrison. I mean, if you can let me continue on my bond, it won't happen again.
Well, first of all, I'm going to put you down to reappear on February 21st so that we can check on the attorney status. What kind of a bond did you make and with whom?
Had $2,500 bond with Campbell.
Your Honor, he has pending misdemeanor cases in Boone County District. We're trying to find out right now if there are any FTAs on that one also, Your Honor.
When you that was really a $25,000 bond, I'm looking at the Campbell document where you had to pay $2,500 for it. Is that what
Right,
you're talking about?
right. Yes.
Where do you live?
Well, it's kind of up in the air at the moment. I was in the process of moving when I got arrested, so I don't know how that went.
Moving from where to where?
From my shop to a friend's house.
Where's your shop?
in Harrison,
Okay,
as Lambert's Auto Body.
I see. And, so if you were able to bond out, where would you be living?
Well, either at my friend's house or at my ex-wife's grandpa's house, I guess.
I mean, the issue for me is you had a fairly substantial bond up, and it wasn't, concern about it wasn't sufficient for you to make sure you got to court back in December. I don't understand that. When the court gives you a date to appear, that's a court order. And
Yes, sir.
It's a little difficult for me to understand how you could not, how you can been in front of the judge and told to reappear on another date and then not remember to appear.
It was-
But anyway, that's your issue or your problem. If Campbell Bonding's willing to go on the bond, I will approve that. The reinstatement of that $25,000 bond, and I'm telling you right now, you're to appear on February 21st.
Yes, sir.
And, so it's no confusion in your mind, that's here in Mountain Home on the 21st.
Right.
All right.
Yes, sir.
So he is aware Boone County District shows he has failure to appear there. So even if he's bonded on this bond, he's gonna be sitting in jail until he takes care of what's pending and also in Boone County District.
You're gonna have to somehow, in order to get out on this bond, you're gonna have to figure out how to deal with Boone County District Court because you didn't apparently, I don't know what you meant by confused one with the other. You didn't appear there either, apparently. So, well, you don't have to explain. Don't worry. I've made my ruling. You'll be eligible for release on this $25,000 bond if Campbell Bonding's willing to stay on the bond.
Okay.
But if otherwise, your bond is at $25,000, and you'll have to make a new bond. So that's your status, and you need to do that knowing that you're going to have to make arrangements with Boone County. Probably the best thing you can do is get your application in and get in communication with the public defender to discuss your case. If you don't bond out, I would assume the public defender will come see you. Mr. Cooper, who's in court today, will come see you about this. But if you do bond out, the very first thing you need to do is contact the public defender's office, make an appointment, and get in to see them before you come back to court on February 21st. Because you need an attorney right now in the worst
Yes.
way. All right. You may be excused at this time.
Thank you.
Court calls 2019-46, State of Arkansas versus Andrew Lampkin.
Yes, Your Honor.
All right. Mr. Lampkin, you're appearing. Can you see the courtroom?
Yes, sir, I can.
The charges against you that you're appearing for arraignment on are failure to register as a sex offender, forgery, and that is a C felony, and forgery is a C felony, and another count of forgery is C felony. So all three counts against you are Class C felonies. Have you made any arrangements to be represented by an attorney?
Your Honor,
No, sir, I have.
Your Honor, Mr. Lampkin told me at the jail on Tuesday that he did not wish to apply for us and he was not going to hire private counsel, that he was going to proceed pro se. At least that was as of Tuesday.
Your Honor, state would also
Miss-
let,
Go ahead.
I'm sorry, Your Honor. State let Mr. Lampkin know we also have a petition to revoke suspended sentence also that we are filing today on him on these new charges.
Mr. Lampkin, first of all, the court will acknowledge that you have an absolute right if you want to proceed pro se. You have that right. If that's what you want to do, fine.
What's that mean?
That means if you want to proceed without an attorney and represent yourself, you're entitled to do that. I will tell you that in my opinion, you are making one of the biggest mistakes you can make in your life. Unless you've had a tremendous amount of experience in court and have learned it, you're subjecting yourself to the possibility of going to the penitentiary because you're not smart enough to either hire or get yourself qualified for a either hire an attorney or get yourself qualified for a public defender. The rules of procedure and the rules of evidence will apply to you, and this court cannot give you special consideration just because you're proceeding without an attorney. Those rules have to be complied with. You'll be up against an attorney from the prosecutor's office, and he'll have all of the advantages in terms of familiarity with the rules of procedure and the rules of evidence and how to conduct a trial and all of that. You'll be at a severe disadvantage. If you choose to not have an attorney, that's your right. But I'm telling you, you're making a mistake. Now, are you choosing to go forward without an attorney?
No, I need to hire one.
All right. So you're going to go out and hire an attorney?
Yes, sir.
All right. Well, I'm noting that on the record.
Okay, thank you.
We're going to arraign you at this time on the charges of failure to register as a sex offender, forgery, and 2 counts of forgery. All 3 are Class C felonies. On those charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. I'm noting that you're planning to hire counsel. Your case, I'm putting you down to reappear before this court on February 21st to check on your attorney status. Your case is set for a trial the week of August 19th, and you'll be set down for a pretrial hearing on May 2nd. So
Okay, thank you.
your next appearance in court will be February 21st. After that, the next one will be May 2nd. And then finally, your trial is set the week of August 19th. Now, is the bond that's set in this matter $5,000? Is that the bond
I
that's
believe
set?
that's right, Your Honor.
Yes, sir. It's $5,000.
All right.
And you know that there'll be a hold on him based on the revocation.
That's what I was going to explain to him. You give a bond of $5,000 on the case that we've just arraigned you on, but you need to understand the prosecutor has announced that based on your on the new criminal charges. Based on the new criminal charges that have been filed in this matter, you were apparently on probation, and there's been a probation petition to revoke your probation based on having violated the terms and conditions of your probation by committing new criminal charges. So if you make that $5,000 bond, you will have a no bond hold to deal with once that's filed, and you're going to have to be arraigned on those charges before we can address that. So just advise you, before you start spending money on a bond, you're not going to get out until we address those matters, and it may not be until February 21st before we can address those matters. So that's I'm just warning you in advance.
Can I be RR? Released on
No,
open
sir.
conduct?
No, sir. I'm not going to OR you. Given the nature of the charges involved, there are charges involving an accusation of deception. Plus, there's the whole nature of the charge involving your failure to register. So At this point, the court's not going to OR you. Your bond is set at $5,000, and you need to be aware of the revocation that's coming down. That'll be the decision of the court. Your next appearance in court is February 21st. You may be excused at this time.